Good evening and welcome to this new session. The theme of this session is called The Shifting Sands, Family Law in a Globalizing Society. This is a very interesting session considering the kind of changes that are happening in the contemporary context in family law. So the globalization process has necessarily led to a paradigm shift in social, political, and economic policies, which in turn have a direct and indirect impact on family life and intra-family relationships. For instance, policies and programs related to migration, labor, ownership and use of land and other property, taking care of children, disabled, elderly, technological advances that have permeated the field of family law. All of this have triggered the need for a recalibration of the established norms and standards. So family law, as we traditionally knew it, has had a transformation of sorts. While some forms of family and kinship are prevalent and recognized in all societies, there's no real consensus on a universal definition of the family. So traditional forms of cis heteronormative, patriarchal, and monogamous marriages based on sexual exclusivity of the spouses are now being challenged and displaced by increasingly diverse forms of marriage, relationships, and formations of the modern family. In India, for example, some of you would be aware that there are trans persons who have knocked the doors of various courts asking for a legalization of marriage based on an interpretation of existing definitions in family law legislations. So the other aspect is the feminist critiques of the family as a site of violence and discrimination. These have prompted a closer examination of family laws in terms of their formulation, interpretation, and implementation. Women's gender and sexuality studies, feminist discourses, as well as social movements offer valuable critiques of exclusionary constructions of the family and power differentials within the family. As a logical corollary, they also urge a reimagination of ideas pertaining to institutions of marriage and the family, as well as rights within marriage and rights arising from marital relationships. Equally, globally, as well as in South Asia, the politics of identity, religious and cultural majoritarianism combined with ethno-nationalism have catalyzed changes, albeit selectively, in the family laws. Personal status laws that are infused by identity politics are often a feature in countries with multi-religious populations. Triggered by a majority onslaught, minority communities have often they assert their identity through personal status laws. However, ramifications of such assertions on women and children of such communities warrant analysis and discussion. And additionally, institutions through which family law disputes are adjudicated have also undergone a sea change, from ordinary courts to specialized family courts to mediation centers. Given the adversarial nature of mainstream court processes that are protracted, time-consuming, and often generate antagonism and hostility between the parties, mediation of family disputes is often advocated. Yet, feminist critiques have sometimes denounced mandatory counseling as a mechanism for reconciliation and have highlighted the de facto power imbalance between parties to the mediation, which is often shrouded by a facade of neutrality. They have also cautioned against a reduced state responsibility, as family law is treated as soft law, leading to dangerous trends towards outsourcing and reprivatization of family law. While there exist diverse socio-cultural contexts that have shaped family laws across the world, there are also convergences, common concerns, and emerging challenges faced across various geopolitical spheres. So this session examines how and to what extent family law has reorganized itself in the wake of global challenges, and whether it has been able to retain its classical epistemological characteristics, credos, methods, and materials, as well as institutions. So to speak about all of this, we have 5 very, very distinguished speakers. We have with us Professor Dr. Srimati Basu. She is a professor, Gender and Women's Studies, College of Arts and Sciences, University of Kentucky, USA. Welcome, ma'am. Honorable Justice Mr. Matthew Cooper is also with us. He's the former judge, Supreme Court of New York, USA. So welcome, sir. We also have with us Honorable Justice Roshan Dalvi, who is the former judge of Bombay High Court, India. Welcome, ma'am. We have with us Ms. Flavia Agnes, who is a co-founder of MAJLIS, and she is a feminist lawyer in Mumbai High Court, and she's also a writer and activist. Welcome, ma'am. And we have with us Professor Dr. Sarasu Thomas, who is a professor of law at National Law School of India, University, India. Welcome, ma'am. So this is our eminent guests who are here with us, and we have with us time till about 7:45 or so, where I will ask questions which would be answered in about 2 or 3 minutes by various speakers, and thereafter we will also take on questions from the audience which the various speakers will address. Firstly, I would like to ask Professor Basu, what are the global and regional experiences and strategies in broadening the concepts of marriage and family and making them more inclusive?
Hi, thank you, Saumya, and thank you, folks, everybody at Jindal for inviting me to this panel. It's so wonderful to be here with you all. There's so much to say on this, right? Because we are at a moment of really exploding ideas of what the ideas of family could be, and indeed what the ideas of marriage could be. Both in India and globally. So I'll just flag a couple of things, right? We were talking just before the panel, right? That marriage equality is marriage equality as in queer folks or homosexual couples marrying has been got into law, right? So there is a whole range of people who would identify as queer who do not come within that panoply, right? And how to, as you know, marriage law in India, in all the personal laws, is so deeply gendered, right? That when you identify as trans, when you don't identify with a gender, like what do you do? Not only with how do you get married, but as we know, if marriage is about a much larger range of rights and resources and money and where to live, then what do you do with that, right? And this has in India actually been a longer discussion. Lots of people have brought it up in lots of communities. We can talk more about that later. But let me just say briefly, I think just to gesture to one of the questions we might discuss later, right? Think of the ways in which the rights of children and the rights of parents are changing, right? With changing notions of surrogacy or who can be a donor, who can do that sort of thing. So the basis of what is family law, what is individual law, and what is marriage, those are That is a very, very brief answer.
Thank you so much, Professor Basu. I'm wondering if Justice Cooper can come in to reflect on some of the things that Professor Basu said, particularly from the American experience, because in India, we are yet not there. But we would really love to hear about the American experience and the kind of cases you have dealt with in courts. You said that for 12 long years, you have handled matrimonial cases. So we would love to hear from you, your experience and your responses to what Professor Basu has just now said.
Okay, and thank you, Professor Uma. And it's a great pleasure to be back with my friends at Jindal Global and to meet all the distinguished panelists. I'm not yet retired. It does say I saw the retired after. I have till the end of the year, so I have 30 more days of this. But it's nice to see what it looks like when one's retired. So I see that. But this has, as you said, Professor Uma, it's been 12 years that I've been in a matrimonial part, and in my state, New York State, Supreme Court handles divorces. I also occasionally handle cases where people are not married, involving custody and parental access. I was struck by the term that Professor Basu used when she said New Indian law, much of the law in the world in family law is gendered. I have witnessed in the last 12 years an incredible, almost a sea change in our law, where gendered is no longer the most prevailing concept. In the 12 years I've done this, we went from where the only parents were a man and a woman to a situation now where it is commonplace to have same-sex couples with children, and even cases now where we recognize 3 parents. So that has been a major change, that no longer is parenthood based on biology. And same thing I've also seen, probably one of the more remarkable things I have seen is how at one point it was, when I first started this, it was so rare to have a same-sex divorce. That was because maybe somebody had been married in Canada, or somebody had been married in one of the few other states that in the United States that allowed same-sex marriage. Now, New York legalized same-sex marriage in 2010. And of course, same-sex marriage is now not only legal throughout all of the United States, I would even posit that even in more conservative areas, it has become accepted and commonplace. And I would say the most remarkable change is that when I have a docket, and I will have one later this morning, if there are same-sex couples, divorce cases, it is no longer something unique. It's no longer something different. It is exactly the same. Bad news, of course, is that the same issues that plague heterosexual couples plague same-sex couples. So it's a little depressing that it becomes the same old things people are fighting about. But overall, there's been a major, major change. We no longer look the whole, and I think Professor Basu touched on this, the net concept of what it was a family is no longer what it was 5 years ago, 10 years ago, and certainly not it was 25, 30 years ago. Family is now something that is totally different than what biology preordains.
Thank you, Justice Cooper. Just a follow-up question from what Justice Cooper said just now. How do we, and this is open to any of the panelists who would like to answer. I'm just trying to, the question I ask is, how do you see the roadmap to the kind of law reform that would be required in India in terms of broadening the contours of what a family is, or the definition of family in the Indian family law statutes. What is the roadmap? How would we go around, go about trying to challenge those contours and to expand it? Any thoughts by any of the panelists?
Good evening, everyone. And I'm happy to be here. And yes, I would say that these contours would be broadened when we consider also the living relationships of heterosexual couples. And now that we have come of age and it is in the legislations and all that, whatever that the courts had done about a century ago has been now in the legislations. Actually, I would say the first case was in the Privy Council in 1927 and then in 1929, when they recognized the legitimacy of children and they recognized that long terms of associations had a presumption of marriage. Now, this was a very good thought. And you see, today the live-in relationship is something like that. And we would be having in these various couples with many years of togetherness and union and things like that, but having various issues which would be discussed before the court, except of course perhaps divorce because of the agreements between themselves, anti-nuptial or partnership agreements. Now in UK it is called a relationship of long duration. We call it live-in relationship, but it's not only fly-by-night relationship but a relationship, and that to that extent we have widened. So anyone, and I don't think any personal laws would be affected then. So for all living couples, it would be the secular law that would apply.
You know, when we look at family laws, I think one element that is very, very strong over there, that it is a sexual relationship, a sexual partnership. It can be monogamous, it can be multiple, but there is the sexuality involved. But what is not stated very clearly, there is economics involved. Whether it is homosexual or heterosexual relationship, primarily there is sort of economic control by one on the other. Now, how do we see it? How do we perceive this economic relationship is not very well articulated. So when we say matrimonial relationships, at least in India, we're so hooked on to the sexuality part of it. And the economics comes in only in the terms of maintenance. And the maintenance is linked again to sexuality. So when we see broadening up the partnership, etc., we need to re-examine the sexuality part of it. And we need to again negotiate the economic part of it, whichever kind of relationship it is. And that's where we get stuck. And in India, where we are very, very far away from recognizing transgender, surrogacy, all of that, we still are stuck in these very basic equations of control of sexuality and control of economics, one pitted against the other. Whether it is in religious-based personal law, secular law, or like Domestic Violence Act, wherever we go, there is this element of sexual control, and there is this element of economics and how it plays out. I don't know globally how it is worked out, but in India, we still are like into these very, very basic notions. So if you take out sexuality and if you take out economics, what remains in that relationship and why should courts have to come in? It's only when these two elements are there, there is a need for courts to determine. But otherwise, it would be a civil partnership between people, 2 or 3 or whatever. And what remains is the only aspect of child custody, child maintenance, and access to. So we need to like separate them, look at them separately, and see in the global context how things are moving. Whether it is in Africa, whether it is in South America, whether it is among the native communities in America, wherever it is, we need to examine where we are moving and how a new definition of family needs to be evolved.
Thank you, Advocate Agnes.
Can I just add one thing? I don't want us to get stuck on the first question, but let me just add, just to go across all the questions.
Yeah.
Judge Cooper started by saying, things are just the same in whatever initiatives, and I think that's right. And this is why, I often turn to Flavia's work on, for example, on attempts to make matrimonial property, right? Just a basic recognition of people's rights in marriage, right? How do we do that? How do we do, I mean, multiple partners is not a new thing in India, far from it, right? Monogamy is new.
Yeah.
So, I mean, that's the question, right? Recognizing it earlier was one thing, and what to do with it now. So I'm curious to know, I would just like, maybe we could discuss later more concretely, like, how can we do that? How do, like in the Hijra community, which has existed for a long time, right? How do different partners involved, let's say 4 people are involved. What are their different rights in it that don't just always go through that husband and wife kind of thing? And I think in the US too, that's a concern, right? That lots of communities, for example, I mean, I feel like it's very odd to be from India and have this in your future, I mean, in your past, that polygamous communities here and polyamorous communities are both making claims to economic rights in partnerships, right? So that's a thing to keep.
Yeah. Thank you. Thank you for adding that, Professor Basu. I'm moving on to another important area, but if we do have time, we will revisit this question towards the end of our conversation today. But my next question is to Professor Sarasu Thomas. And this is particularly on the increasing religious fundamentalism, which is a worldwide phenomenon and definitely a phenomenon in India. And what are the kind of challenges that you see that posing to the legal recognition of diverse forms of marriage and family within family laws, and how can they be addressed? So we are still on the topic of, diverse forms of family and family laws, but we are now bringing in the element of religious fundamentalism and its influence over family laws. Professor Thomas?
Yes. Thank you, Saumya. I think this is, quite clearly tied to the first question, as you said. And certainly when we look at global experiences and how they operate in India, although we do have rights, I think both Flavia and Justice Dalvi refer to, live-in relationships. But, all this has not, and though you have some recognition in the DB Act, this has not really moved into other areas that matter, like an equitable right to the matrimonial home or to succession. We also see that in some areas, you have, for instance, your Joseph Stein case where we saw that, adultery is a matrimonial wrong and it should not be criminalized. But then again, you have divorce that now is criminalized in the Muslim Women Protection of Rights on Divorce Act. So I think we are seeing a lot of cross signals, which may be possibly because of the phenomenon that you so well described in the beginning. I think there is also a concern of, more and more anti-miscegenation laws and policies, which cast barriers as far as rights of couples are concerned to marry. And, we are all familiar with the so-called love jihad case, which highlighted the resistance that we have as a society to women's agency. When you tie this in with older problems that are there, and I know even as a student, Flavia used to keep telling us about the courts focusing upon Homa and Saptapadi, for instance, could mean that, in many of these cases where there are mixed marriages or marriages that do not follow certain caste customs, or let us say runaway marriages by children, this could mean not just a social backlash, but also legal implications in terms of legitimacy and succession law. And I feel that that's something that really matters, and succession, women's access, children's access to property is something that has not really received much attention in all this. Even when we talk about broadening family laws, how do we also change other laws which will ensure that all rights that a person should be entitled to and should receive will be protected, is something that is often missed out in discussions and writing.
Thank you, Professor Thomas. Since you also referred to Flavia's work, and we have both grown up actually reading her work, and she has of course been mentored me as well. I really would like to bring Advocate Flavia Agnes in to speak a little more, just in relation to the points that that Professor Thomas was saying about discriminatory family laws, because you wrote an article recently about how all laws are all family laws are discriminatory. Yet, given the communal context in India, it is only certain laws which get the focus. So I really would like to get your responses to what Professor Thomas was saying just now.
You're asking me?
Yes.
Shamim? Yeah.
Yes, yes.
Okay. It's so nice to be on a panel with who used to be my students, the young people now become authorities on family law. It's really, I mean, I feel ancient, but also I feel very proud to be here. Anyway, I think our family laws have changed quite a bit when you enter into the litigation arena, when you see what's happening in the courts. Unfortunately, that's the arena I'm in touch with. But as family laws in India, I don't know elsewhere, are so archaic, so patriarchal, so feudal, and that's the basis on which that is the basic structure on which everything else gets superimposed. But I've never questioned that archaic framework. You'll see it in so many different ways. See the case of Hadia, for instance, and the attitude of the Kerala High Court judges about the parental control. See what is happening in love jihad and what's happening with law, that you need a parental consent. So it's not a relationship between two adults as seen abroad, but it is a relationship of families. Now, what is happening here, when you see a feudal structure, the feudal property had a particular character. Then we moved on to capitalism. And capitalism property again has a very, very different character. Now we are into post-capitalism, and women's rights to maintenance, to everything else, shared family house, matrimonial home, all of these are still measured in archaic terms. And they're not, though we say Hindu Marriage Act is contractual, or even Christian Marriage Act, the contractual element that we contract into marriage and we determine our rights and responsibilities into that contractual agreement is not accepted at all. So we are like fossilized over there, and onto which we have newer ideas. Let's get into agreements, prenup agreements, something else. And this is how actually we play out on our family law. And as you say, Saptapadi, Homa, Pati Parameshwar, all these concepts are judges are still thinking in those lines for women's autonomy. So when we look at like not having sex is cruelty. When I just wrote this article and I went through all these judgments, and at another level, we are saying marital rape has to be criminalized. So you can see the disparity between here, the control of sexuality to denial of property. This is the basic framework. So when we come into other alliances, multiple partnership marriages, how do we frame this property, which is termed in feudal, heterosexual relationships? And how do we compare control of sexuality with economic rights? The homekeeper, the caretaker, and then there is a whole lot of property. Now, that property is not agricultural property anymore. That cannot be attached. It is an illusionary property. You cannot touch it. So when we have all these different elements over there, I feel our family laws are not only not evolved, we're still stuck into religious personal laws. What Hindu marriage is, what Muslim marriage is, what Christian marriage. I mean, what happens in the court is so very different, and our judges feel not equipped enough to deal with it when we examine family laws at all. So they need to evolve a new parameter. But most judges don't write, they don't analyze what's happening in today's context. So, and most lawyers also do not write. So there is very few actually who look at the situation on the ground and are able to theorize and analyze it to have a framework for law reform. So we're still like triple talaq, criminalization of triple talaq, or we are still into whether there should be a theory of breakdown of marriage, restitution of conjugal rights. We're still stuck in those. So according to me, people's lives are very different. And of course, structures are so very different and there is no connection. Into which we want to now bring in homosexual relationships, same-sex relationships, etc. And I always wonder how that is possible when there is a theoretical framework is not evolved at all. So I think Saumya, Sarasu, all of you, it's up to you to first lay the ground, create the basic structure onto which a law reform can actually take place.
Thank you. I would like to ask a related question to Justice Cooper, because Advocate Agnes spoke about archaic family laws in India, and she spoke about the control of sexuality with economic rights. Now, India has had, India's family laws have had, because of the colonial rule in India, there's been a very, very strong impact of that. And I believe that there was a similar impact in US as well. For example, doctrine of coverture, doctrine of one flesh. These are all, very archaic concepts, and those now govern what we have as restitution of conjugal rights, which we are struggling to strike off from our family law statutes. So I would like to ask you as to what has been the US experience, and has the US managed to at all get rid of these archaic family laws and lay a new foundation? And are there lessons there for India?
Okay. And this is one of the great opportunities to be optimistic. I can bring some good news, hopefully. Just with one caveat, my experience in New York State might be different than maybe what Professor Basu sees in Kentucky. There's a difference between our regions, but I think it's becoming less so as we progress. But the best thing I can say is that the concerns about patriarchal, about feudal, those have been somewhat, at least I've not totally eradicated. They have been modified in a place like New York. New York has equitable distribution of property. It means that no longer property is not distributed when there's a divorce based on whose title the property is and whose name is the property. And it's based on what contributions each side made to the marriage. And there's a presumption that that a contribution doesn't have to be direct. It can be raising the family. So if we have a wife stays home and raise the children, that is and provided for the household, that is considered a contribution that entitles her to. What you hear back there is the New York ambulance going by. So sorry, I'm in the courthouse today. So that has been a change. I've also, in my 12, 13 years, I've seen the situation now where women now make far more money in a marriage than a husband does. So we have women paying support. We call it maintenance here. Sometimes the terms used throughout the essay is alimony to husbands. So that has been a total change. So it's the whole, and there's no longer a presumption. I mean, New York law, or the requirement to pay maintenance, to pay alimony, was based originally on the concept that a husband is the Lord and master, and he must do something to provide for a wife in the event of divorce. That concept has totally changed. Based simply now on on needs of the parties, on the ability to be self-supporting, on the ability to maintain a lifestyle. So there's been some major changes. One thing I also would love to add is that even within a traditional heterosexual marriage with when there's a divorce with two parents, the role of each parent, is changing. It used to be that the mother would be the parent who would be presumed to be the custodial parent, and the father would have limited access. Father would have Tuesday nights and weekends. That notion has changed radically. We are moving towards a presumption, not yet in New York, but actually I think it may even be in Kentucky, believe it or not, because a lot of other states have sometimes been more progressive in many ways than New York State, where joint custody is the presumption, where it's deemed that both parents will have an equal role in deciding how their children are brought up, and that there will be a presumption as to 50-50 access time, that children will spend time equally with each of their parents. So there's been some monumental changes. We don't face some of the significant issues that India faces, although fundamentalism plays a major role, or all too often plays a role in certain areas of our country. It doesn't dominate the way it does in the US. So we have been basically able to be somewhat free of religious pressures. Although I have to say, I do see it more and more, and especially I do as we are in an international society. New York is very an international place. I'm occasionally called upon to decide when there's significant old views. Though in our society, when the country where the parties came from, the father had this role, and the mother had this role. That is something I have to deal with all too often. But in final analysis, a lot of the concerns that were so eloquently stated by Ms. Agnes have been, if not eliminated, have been at least lessened in my state, New York State.
Thank you, Justice Cooper. I think there were two very important points you made. One was related to joint custody, and the other was related to equal right to maintenance. Both of these are important for us, so I hope to be able to ask questions related to both, but my primary question now would be to Justice Dalvi, and this is specifically on what Justice Cooper talked about, equal maintenance rights. And we know that in Hindu Marriage Act and in Special Marriage Act, we have this provision by which a woman can be asked to pay maintenance to her husband, right? So, in the garb of equality. So how do you, as a judge, how do you see that working in the courts of law? We have had some judgments, of course, which say that, an able-bodied man cannot simply resign from his job and then sit at home and ask for maintenance from his wife. But what have been the trends in the courts? I would like Justice Dalvi to speak about this, please.
Yes. You see, I was a family court judge in 2004, and I have granted maintenance to a husband. The wife was earning, she was earning much better, and she did not care for the children. He was caring for the children, and I granted him maintenance, and also, of course, the children. Now, there have been cases like this reported often on. It is not that it's not so. There is equality, I would say. And therefore, even the legislation does not mention wife and husband. The legislation maintains to the respondent. So whoever is the respondent. Similarly, there have been cases before me where the wife earns almost equally and as well. And there have been cases where she cannot get maintenance, but there have been cases where she has not been able to because of whatever was the relationship between the parties when they were happy together. And she didn't, like, there was one dentist before me and with a businessman whom she had married. And he said that she is a professional, so she's not entitled and let her do everything. She said, no, I gave up my practice. I did not practice because that was what I thought that we'll do in the marriage. So now if I've got to, then I've lost on so many years and I must have an infrastructure. And I made him pay for the dental chair. And I said, now you stand on your own 2 feet because we don't have to always give the fish. You have to give a rod so she can fish. So all of those considerations, depending on the facts of the case, are always before the court and are given for maintenance. Now, even for custody, for example, it is that we do have the concept of joint custody, but not in all matters because our sociological position is such that a child remains with the mother and therefore the mother does everything generally for the child, etc. But when you are considering joint custody, what you consider is the parental obligation, the parental responsibility. The man must come and say, not only that I want to spend 2 hours, but I want to do something fruitful in those 2 hours that I spend on that Tuesday evening or whatever that day is. Okay. So that is what is in one of my matters today. Now in consultation, I have done bird nesting. That is also in America and just taking ground so that the children remain in the same house and the parents go to the children to sort of, do things for the children. So these are those new things which are coming up and can be used, but depending, of course, on the facts of each case. Now, in my case, it was a nuclear marriage, nuclear family. The mother, after the separation, was with the children. So I told her that the father will come home. And she gave him several meals and he went for several dates, etc., to be with the children so that the children were not kind of dishoused in that sense, go here, there, etc. And depending on the facts of each case, we try out various things, at least I do, and many judges do. But of course, that does not talk about fundamentalism. We are still not progressing to the third section. So that's it for now. These are the differences.
Yeah, thank you. Thank you so much, Justice Dalvi. Just taking on from what Justice Dalvi talked about and what Justice Cooper talked about, equal maintenance rights. I'd like to ask this question to Advocate Flavia Agnes, and this is to do with gender neutrality in family laws, because very often, this is a question I'm sure, Professor Thomas has also faced this in class, where students are often asking us, what about gender neutrality? The concept of inclusion and gender neutrality has become the current mantra. But how do we see that in terms of family laws, given the power dynamics, unequal power dynamics within the family? Advocate Agnes.
Thank you so much for asking this question, Professor Uma. Here I want to say, I want to flag 1 or 2 things before we proceed. And one is the instance of domestic violence in India prevailing. When we say neutrality, equality, etc., I do not know what it is in the US. I'm sure there is a lot of domestic violence there too. But in India, a lot of studies show the extent of domestic violence and the control of the wives through domestic violence. So that is one important factor we need to take into account. The second factor, like Justice Dalvi mentioned about a few cases where the wife was earning more, etc. And I just want to, like, a small correction. Saumya, Special Marriage Act, under Special Marriage Act, husband is not entitled to claim maintenance. Okay. Only under Hindu law, he is entitled to claim maintenance. And that hangs like a sword on our head. That he says, you go to court, I will resign my job and I will claim maintenance from you. Now, this is one issue, that domestic violence. The second is the gendered roles. We still go by, even our courts go by the gendered roles, which are very patriarchal, very ancient, archaic value system, what a husband is supposed to do and what a wife is supposed to do. For instance, a Hindu wife not wearing sindoor or not wearing Mangalsutra, the husband can perceive it as cruelty, and the courts also can perceive it as cruelty. Or for that matter, like not covering your head, not touching the feet of the in-laws, all these amounts to cruelty. The husband perceives it as cruelty. Even filing a 498 case, the husband for cruelty or dowry demands, the husband perceives it as cruelty. Not preparing meals on time, are not preparing meals as his mother used to do, etc. These kind of very subjective notions, and that she must prepare the meal. Now, when we look at, when we go to examine the divorce petition, now we have fixed terms like cruelty, desertion, adultery, etc. in matrimonial law. Applies to men and women equally. But what men perceive as cruelty is very different what women perceive as cruelty. Like for a woman, throwing her out of the matrimonial home, domestic violence, not giving her access to children, not allowing her to go out to work. Now, all these she claims as cruelty as against what husband perceives, the notion of gendered roles, which he has not fulfilled. So it's like comparing oranges and apples. There's no comparison at all. And on this, not having sex with me, terminating a pregnancy without asking me, all these instances come as, in reported cases, cruelty by the wife. So when the situation is such disparity, and we apply the principle of equality, it causes so much of inequality and injustice to the woman. So, and then we have this concern, we have many women judges now, and unless these judges are able to perceive that equality within family does not exist, and there is so much of inequality, and they are able to decide on this issue, there will be greater injustice. And that is the grave concern for me, particularly with the judges being apologists to patriarchy. They don't have the confidence to challenge their male colleagues, particularly the younger judges. Madam Roshan Dalvi is an exception to this principle. Very few judges are there. We have Gita Mittal, we have Prabha, Sidevan, etc. But overall, the judges, younger judges, I've seen it, younger judges under the Domestic Violence Act, I've seen in district courts, etc. The women judges want to be more patriarchal than the male judges. And that is where we are really concerned about that what kind of justice will women get here? How are these judges judging the women who come before them? And the maintenance amount they give, it's so paltry that it's not for the woman, as Justice Krishna had said, to keep her body and soul together. Even to that extent, it is not possible. Then she has the responsibility of her children. Meanwhile, husband goes out and marries. She is divorced, but still that sexuality pervades so much that she is burdened with that conceit that even if she has a male friend, etc., her maintenance is going to stop. So these are kind of a concern that we have. So when we say equality, we have to have a society that is more or less gender equal. And we don't have that society. And we're talking about, say, places like Mumbai, Delhi, etc. But what about the smaller towns? What happens over there? The families are still joined. The roles are so fixed. And in that, this woman goes to court. She wants a separation. She wants maintenance. And if there is an equality yardstick that is applied, and you're not able to specifically understand the role that woman is called upon to play, and apply the notion, okay, she's earning, he's earning, she's not entitled to maintenance, etc. This will cause great injustice. So your students need to understand this, both for Satsuma and for Saumya. I want to say very clearly that we cannot apply the yardstick of gender neutrality within a gendered society, within gendered roles. Add to it domestic violence. And when you see domestic violence over there, and when you see equal access, etc., now that becomes a weapon to subjugate women further. And women are ready to give up their maintenance in order to not to have joint custody. And that is like, I mean, they're petrified about this whole joint custody. And now I think we have a new concept coming in, just coming in, that a lawyer for the child. The child needs to be represented. And what one has not seen is this is a very, this whole notion is pushed by men's rights group. So men are there, women are there. Now they want to have this additional leeway. So we'll have lawyers for the child. So the child and lawyer and the men's lawyer, there's sort of coalition between them. And the woman's lawyer, most of the time, like not as high profile as the husband's lawyer. And you can imagine what will happen in the family court. This notion is just coming in. This notion will catch up, saying that internationally there is this kind of concept that a child needs to be represented. And here the women doesn't have a kind of a leeway to hold on to. And maintenance is not looked at by the judges, but access and joint custody is looked at. And this has been a campaign that's going on for so long, and something that women are very scared of. So we really need to know how this concept will play out.
Thank you so much, Advocate Agnes. I think this concept that you're talking about, in a sense, you know, I can draw parallels to criminal law, for example, where you have the victim's lawyer. But and that came in because there was a recognition that the interests of the prosecutor would not always serve the interests of the victim. And that's why victim needed to have a lawyer. But when we are talking about, you know, the child having a lawyer, who's going to instruct that lawyer? And you know, so there are many questions that arise from what you have said. But I would leave it open to any of the panelists. Yes. If you would like to say something more about this concept of lawyer for the child.
May I, Uma?
Sure, please.
Yes, okay. So it is called CIL, Child Independent Lawyer. Okay. So the CIL is going to be appointed. There is a circular which is issued by the High Court that has been now circulated. Now, why is this so? The whole concept has arisen like this. Maintenance is different and child custody is different. For child custody, for visitation rights, for access, whatever way, contact, whatever you call, it is that a child needs both the mother and the father. The child wants both the mother and the father, and the child must have both the mother and the father, other things given being equal. So there are many couples who cannot get along together and therefore they separate, but both are good to the children. Like they say, we are divided in matrimony, but united in parenting. Okay. So this is that concept. Now there is perceived that there's a lot of child parental alienation. So if a child is with one parent, it's not necessarily only mother. I have come across a case of father also and mother also. So there could be alienation, but then the children cannot really respond to that. They are living with one parent. So the children are at crossroads and, you know, they are at cross purposes. Do I talk to my father or do I make my mother happy? And vice versa whenever they are with the father also. That is why they say that we are not looking to the needs of the child. So this lawyer will show the needs of the child. Now this lawyer must be trained in some form of psychology also. It's not only law and not only legal things, etc., that the person should know. And I think it should develop very well, and we should all give it the right support. Instead of just saying, you know, whether we are pro-mother or pro-father or something, you have to be pro-child. And like I told you in this matter which I'm doing now in consultation, this bird nesting has, I think, helped because the children will slowly then get the father. The father goes to the house, he does his work online, and the children can come to him and things like that. Now, we would never have known what is happening with the children otherwise. So, and the NGOs are also being recommended to be CILs. So even the NGOs like, you know, Flavia could be, for example. MAJLIS could be, for example. So they could be appointed. Lawyers also can be appointed. Social workers, sociologists can be appointed. We are going to have a kind of a mixture. And let's see how it flourishes. I mean, let's see how it goes. But I hope it does go well, because we should not really think of mother and father. We should think of the child. It is the right of the child that is very important. There's no law which says the mother is entitled to this and the father is entitled to this, so far as children are concerned. It is only that who can be the guardian. And when you are a guardian, you have to see that you are a fit person to be a guardian. So when that fitness is seen, what we find is that both are fit otherwise. They may be quarreling amongst themselves, but they are fit for the children. And let the children have both of them. That is the spirit. I hope
I just wanted to add a couple of things here. Hi.
Sure, go ahead.
Yeah, I think that's the question, Flavia. I thought you would be interested to know that not only are domestic violence rates in astronomically high in the US, complicated by gun violence, right? Complicated by a certain kind of nuclear family structure and a sort of, there are ways of control that are very particular to the US. But rates of domestic violence are among, sorry. Rates of domestic violence are amongst the highest in the South Asian communities, actually, very, very, demographically, that's true, compounded by other things. But I think just to say that, right, like, again, equal custody, of course, right? I mean, one of the most painful things to me about watching family courts was, having children come into the courtroom. This often happened in Kolkata for custodial hearings. It's just super painful. So all good, but every time you're in a family court, right, domestic violence is front and center of most cases going on, right? And so that complicates everything about equal custody, about matrimonial property, etc. So I just want to add to that.
Yeah, thank you so
much. If I could just say just two things to follow up on what Justice Dalvi said and Professor Basu said is one.
I think Flavia may want to mute.
Yeah, I think right. We're both.
Flavia, if you mute, we can all hear each other.
Okay, so I would simply say that an attorney for the child is a fundamental concept in New York law. And I think in most states in the United States, children are represented by lawyers because the notion is children should have a voice, not necessarily a determinant, that they don't make the determination, but they should have representation. It used to be, up until about 20 years ago in New York, an attorney for the child would be there to tell the court what the attorney thought was in the best interest of the child. Now, the notion is that the attorney for the child will advocate for the child unless there's either the child is too young, or that the child may have the child's judgment may be impaired. And one of the things that is looked to as impairing the judgment is something that I think Justice Dalvi brought up, is alienation. So if the attorney for the child believes that a child has been alienated, even though that child is maintaining a certain position, is professing, I want to be all the time with one parent, the attorney for the child can come forward and say, I'm exercising independent judgment and I am advocating for perhaps a different course. But this is I almost never do a custody case without having the children represented by counsel. The other thing I would also point up that Justice Dalvi talked about training for the attorneys for the children. In New York, in order to be an attorney for the child, you have to go through certain training. You have to be certified to be on a panel. So we're looking for lawyers who can deal with children, who can have a good relationship with children, and also take a nuanced position. And they often it's a difficult role because they're between both parents, but often the attorney for the child can be even more than the judge, because sometimes judges have so many cases. You need another person involved in this, another force to try to get the parents to understand that incredible conflict is only going to produce conflicted, unhappy children. So in my court, attorneys for children play a really major role and a very, very, very important role on behalf of better families, more equal, just families, but most of all for children who come out of divorce okay, because children shouldn't be the collateral damage in battles between two parents who dislike each other. I think we all can agree on that.
Thank you, Justice Cooper. I now want to ask Professor Thomas a question related to technological advancements. This is another global challenge that we see. How have technological advancements impacted child rights within the realm of family law? Are the traditional categories of family law of the legitimate and illegitimate child, biological, adopted, and surrogate child, are they irrelevant and outdated, or do they still play an important role? Professor Thomas?
Yes. Thank you, Saumya. I also wanted to quickly respond to the earlier conversation. What limited frameworks we had, during the pandemic, we saw that all of these collapsed, whether it was joint custody or it was responding to domestic violence, or whether they were courts. And we were not able to, quickly respond to crisis situations. And I know there were ideas floated around, including, I think, Indira Jaising had suggested that the police should, take on the role and at least go and respond when there is an incident of violence against a woman or a child. So when we are looking at modern times, even the existing structures have not been able to, respond to distressing situations. It's quite far away to think about the law quickly responding to technological advancements. And we know that there is a huge gap between the way that society has moved and the way that law has moved. The law still has a very, is very strict on questions of legitimacy when it comes to succession. It does discriminate between a legitimate and an illegitimate child. But having said that, there are also other areas which are fast moving, which family law has not yet been able to cope with. And surrogacy that you have mentioned, question is one of them. Unfortunately, challenges to questions of adoption, to questions of surrogacy will come up only after the parents pass away. And the relatives come out of the woodwork to grab the property and say that, you are not the legitimate child of so-and-so. We've seen that happening in adoption law, which still has a number of loopholes. And we will see that happening in surrogacy law as well, because despite all the advances made in rules and regulations, you still have Section 112 of the Indian Evidence Act, which is very clear on what maternity and paternity would be. So definitely we do need to, the law needs to respond to all this. And it is sad that, we are not able to change as quickly as we would like to in areas of family law, even without touching personal laws at all, in areas of domestic violence, in areas of just deciding, who is the parent. Justice Cooper had mentioned, for instance, situations where you can have parents. And while there are customary examples of that in India, like the Dvayamushyana form of adoption, those seem to have fallen into disuse and they're not used very often. I think it's high time that we explore all these areas, because 20 years down the line, we are going to have, cases where relatives of children who have been adopted or are born to surrogates, are told that, no, you're not the legal children and have no rights to succession. So when we're talking about changes in an area of family law, I think we sort of need to look at it holistically, because it's so connected to the question of rights. So we can't just limit our discussions to issues of marriage and maintenance and custody, but we do need to look at issues like matrimonial property, and succession as well.
Yeah, thank you. The other day, I was moderating another discussion where Advocate Malvika Rajkotia was speaking, and she was talking about a case where there was a surrogate child, and the husband was arguing in the court that somehow he had a superior right to custody of the child, and this was an infant. He had a superior right because it was a surrogate child and it was not the biological child of the wife. So in that sense, surrogacy plays in so many ways in the court narratives as well as other aspects like, you know, paternity tests, for example, which have been playing a role for some decades now in the courts as well. Advocate Agnes, would you like to add anything on the on legal practice and technology on family law?
Not in particular, because I've not dealt with many technological issues,
Okay.
but it's going to be a very important part of family law in future in many aspects. To prove adultery, for instance, phone calls, etc., are today accepted as evidence. Of course, paternity to be determined by technology. The issue of surrogacy and how it will pan out is another very important factor. Even proving documents, proving emails, where certain allegations are made, etc. The courts are beginning to accept all these things. Earlier, these things were photographs, etc. Earlier, these things were not accepted. But today, I feel what is most important, that the control of woman's chastity, that using all these things to say this woman was adulterous, I feel somewhere the courts are not like paying importance to this, that that all these documents, conversations that are recorded, etc., against a woman, courts do not take it very seriously, and that's, according to me, a positive thing. The husband lay a lot of emphasis. I know hidden cameras in the house, a lot of these things happen. Yeah. And from my own experience of family court, I see that most of this the judges don't accept as evidence. What they do accept as evidence is like when you have to do a paternity test, etc., the relationship with the child and the father, etc., and not that surveillance and control. Husbands think that with this all this technology, they can do a greater surveillance upon women, and they will have enough evidence, etc., planting evidence, recording conversations, all of that. And I see the courts not like taking these things very seriously. So somewhere I feel that is a very positive element. Surrogacy has not like come up very strongly, but it is bound to happen, particularly as she mentioned in the inheritance, etc. And what are the like the legitimacy of the child and the rights of the child vis-a-vis the property of the parents. I think this is something we need to be very clear. At this moment, we use the word adopted, but we do not legally you have the word surrogacy. So if child is surrogate, then what are the child's rights? What are the parents' rights? What are the access rights, etc.? We need to look at it very carefully. Regarding this representation of the child as a lawyer, in a way, it is going to reduce the burden of the courts, because you can determine the wishes of the child, etc., evidently. But unless there is proper training, a proper understanding, and the power equations between the spouses, unless that takes place, it will only add to the union being unequal, where the husband is able to manipulate the child. So we have to ensure that the neutrality is there, welfare of the child, best interest of the child. These are there, and not using it as a manipulative tactics. So you have to have lawyers who are beyond this equation between husband and wife and looking at the welfare of the child.
Yeah, thank you. I'm just going to, it's 7:57 now, and there are many interesting questions that have come in, but I would like to ask one last question, which is on mediation, before we move on to the audience questions. Should mandatory court-assisted mediations in family law disputes become the norm? Can mediation be conducted in a manner that acknowledges power differentials within the family? This is a question that I'm opening to all the panelists, whoever would like to answer this question. Justice Dalvi Justice Dalvi, you're muted.
Okay.
Yes.
So here am I. Yes. Mediation has taken ground, and it's a very good thing. We had started it in the family court when I was there also. Flavia was one of my first mediators. And it did not, I suppose, take ground at that time. But now we are training even law graduates, the law students. There is a course of Masters in Law in Mediation. And this is going to have a completely different work culture, because a lot of these things can be settled in mediation and negotiation and facilitation of that negotiation, so that the court's roles will become lesser. The work culture should be different, of course. It requires a lot of client counseling. Both of the lawyers must have that kind of mindset that we would be semi-judges, that we would be able to negotiate, that we will refer to a very independent mediator and get these things settled. So there are so many issues which could be determined in mediation, and then you can file consent terms, and everything comes to an end. It should take ground, and it is taking ground. And I suppose that the next generation would see a great deal of difference in mediation culture.
Thank you. I'm now going to...
I have a question. Saumya, I have a question.
Yes.
So with this, I feel the family relationships are going out of the court majorly. And they're either private partnerships or they're mediated. So in that sense, the whole issue of like reform in family law or uniform civil code, all of this have become redundant. Matrimonial law in a way is a law for communication, for settlement, to arrive at a harmonious ending. We do have mutual consent divorce, but this is moving further, even when there are differences, how we can settle these differences. But the danger of it is, so long as it remains neutral and the mediator is trained, etc. But what happens when the mediator comes with their own biases and with the fixed notions regarding patriarchy, gender roles, etc., then it will be detrimental for women's interests. And I would still think courts would be a safer place for women to claim their rights rather than going by the mediator. We have seen a lot of cases where things go wrong in mediation. So we have to ensure that the mediator is unbiased, is understanding patriarchy and gender roles, and is able to negotiate in a way, put their weight along with the women rather than the patriarchal value system. These are some of the very important points. I agree with Madam Dalvi. I mean, she started it, and a lot of cases do get settled, but we have to ensure that this doesn't boomerang upon women. So I feel that today matrimonial law, as a formal law, as a court defined law, or as a statutory law, is losing its place and is getting into informal law and mediation and negotiations. So in a way, it is positive that we can see faster results, but in a way, it may not be so. And we still are in the danger of women's rights getting, manipulated or losing out on women's rights. So we need to ensure that.
Thank you. I'm now going to...
Oh, I was just going to say one thing, Joyce.
Yes.
Hi. Is that our courts in New York are overburdened. My understanding, it is nothing compared to how the caseloads are for Indian courts. I'm told that those are staggering. And we have had a great emphasis on mediation because, as they say, justice delayed is justice denied. So to move cases along and to get people to have some resolution of these issues is so important. And when I go down to my courtroom, which I'll do in about a half hour, I am going to send a number of cases to trained mediators to help resolve these issues. It plays a very important role in our system of justice, and I think it's becoming something that will be global. Right.
Thank you, Justice Cooper. We have exactly 13 minutes left for this session. So I'm going to ask some questions, but I request very, very short answers from all the panelists so that the viewers can also have some kind of an answer for the questions that they are seeking. So the first question is regarding Uniform Civil Code. I'm requesting a very short answer, and I'm really sorry. It's something that we can talk on and on for hours together. But the question is, considering the reliance on diversified religious beliefs and personal laws, can India really move towards Uniform Civil Code by learning from global counterparts? Yes, Advocate Agnes.
I just want to say, I've just given the answer right now. Like when you're looking at mediation, we are looking at a child advocate, we're looking at settling disputes away from the statutory law. So I've already answered this question that today in the family law, it is the religious part of it does not play an important part. It is how we mediate and negotiate the rights vis-a-vis each other. So in that sense, according to me, this entire UCC has become a puzzle. It is no more relevant. You may marry anyway, you do saptapadi, you don't do saptapadi, you enter into a contract, special marriage act, all these things. But today when we're talking about rights, there is a uniformity in rights. There is a uniformity in our perception about what is marriage. And the marriage is moving forward from the patriarchal, paternalistic structure into a global kind of a partnership relationship. And family laws have not moved in that direction. So whether you have a UCC, whether you don't have a UCC, it is what the courts do, what the mediators do, what happens in the court. That's what's most important.
Okay, thank you. I was under the impression that we end at 8:15, but I've been told that we are supposed to be ending at 8 p.m. And we are already 5 minutes late. But any last thoughts from any of you, a one-liner, a two-liner, I would really appreciate.
If I can just jump in.
Yes, sure.
I mean, this is something that always, pops up at any, I think, family law panel. And I would just like to say that it's usually, it comes up in the context of, or from the understanding that, Hindu law is good and, certain minority laws are not, which I think we are very clear that, personal laws should change. It comes from the context that we feel that personal laws are based on religion, and we know that's not true. In a diverse society like India, personal laws may vary based on tribe, on caste, on the state you belong to, in addition to religion and so many other factors. Uniformity is not something that we should aspire to. I think we should aspire to laws that take into account needs of vulnerable groups in families. And we already see that happening through uniform codes, if you wish to call it, under the JJ Act, domestic violence, and so on. So, I think, in a nutshell, as Flavia says, we should not be discussing a uniform civil code, but rather looking at ways in which we address these inequalities in the family that are caused by patriarchy. So allow for diversity, but address these inequalities. And again, as I keep saying, no one talks about succession law. No one talks about the fact that the Hindu undivided family is a separate entity in tax law. That never figures in a uniform civil code discussion.
Thank you. In fact, the Law Commission consultation paper of 2018 also says that,
Yes.
uniformity doesn't necessarily bring about equality.
Absolutely.
So let us
Absolutely.
aspire for equality, and that too substantive equality within family and in relation to rights that arise from the family. So thank you very much to all the 5 eminent panelists. And we have had a fantastic discussion. I've taken notes, but I've not had, there's no time to kind of sum up, but then there are many, many rich thoughts and ideas that all of us are taking away from this discussion. We could think of meeting at other points to carry on this conversation. So thank you to each one of you eminent panelists for this enriching discussion.